Hello, and thank you for joining us for this discussion about equal pay. My name is David Gabor, and I am a partner with the Wagner Law Group, who practices in the area of employment law and HR consulting. We are all consumed by COVID-19 and its unprecedented impact in the lives of tens of millions of people in the United States and abroad. That being said, we have the same obligation today that we had prior to learning of the coronavirus to honor laws that provide for equal pay and equal opportunity. We are going to examine the most recent equal pay statistics, followed by an understanding of federal and state law in this area, as well as trends at the federal and state level. We're going to explore some of the contributing factors for pay disparity. Then afterwards, we're going to have not a David Letterman, but rather a David Gabor's top 10 list of things we can learn about to avoid having problems with our companies. And this will also include ways in which the pandemic impacts equal pay. So grab your writing sticks and let's get started. Oh, sorry, writing sticks? It is just another way of saying pens or pencils. Now, we're going to attack this topic, and I promise attack it with an enthusiasm unknown to mankind. The numbers don't lie. Women are still being paid much less than men. In fact, this is rather alarming, and we'll talk about why that's so in a few minutes. But think about this. Today, the day we're recording this webinar, is March 31, 2020. That is the day Caucasian women have to work in 2020 to make as much as men made in 2019. And for African American, Native American, and Latina women, the numbers are much, much worse. Look at those dates: August 13, October 1, October 29. Now, as a bonus, there's also a date that working moms have to work to in 2020 to make as much as men made in 2019, and that date, June 4th. So let's talk a bit about the different statutes. And the Equal Pay Act is a 1963 act signed by JFK, John F. Kennedy, as part of the New Frontier program. And the Civil Rights Act of 1964 talked about the fact that people could not be paid differently based on gender, race, ethnicity, religion, or national origin. You've got the Americans with Disability Act and the Age Discrimination and Employment Act. All the statutes provide that a person's gender, race, religion, ethnicity, national origin, age, or disability cannot be a motivating factor when decisions regarding how much to pay people are made. And that's a pretty clear statute. And think about it. We're well into 5 decades later, and we still have those alarming statistics that we were just talking about. On the state level, 49 of the 50 states have equal pay laws. Mississippi is the only state without an equal pay law, and there the difference is 23%, which is much higher than it is on the national level just for Caucasian people. So Massachusetts is notorious for a whole lot of things, and one of them is a groundbreaking equal pay law that it passed a few years ago. And I want to talk about that a bit because this has spearheaded more of a transition at the state level regarding not just equal pay, but things such as addressing factors which the legislature in Massachusetts believed contributed to equal pay issues. So the Massachusetts law recognizes that women will continue to be paid less than men if companies are aware of salary history when hiring. The company decides to offer, for example, 10% above a current salary to a successful male and female candidate. The man says he's earning $100,000 per year, and they offer $110,000. The woman says she is earning $80,000 per year, so they offer her $88,000. Both of them got a 10% increase from what they were making before. So the delta between the male and the female went from $20,000, 100 versus 80, to $22,000, 110 versus 88. Massachusetts reasoned that the offer of compensation and benefits should be based on talent and skill, and compensation and benefits history should not be a factor. And that reasoning makes good sense. Now, mind you, what Massachusetts has done and several other states have done is they say discriminatory intent is not required to establish liability in an equal pay claim. So let's talk about comparable work. Comparable work is defined as work that is substantially similar in that it requires substantially similar skill, effort, and responsibility, and is performed under similar working conditions. The Massachusetts law explicitly notes that a job title or job description alone does not determine comparability. Comparable work is not limited to employees who have the same job title, and this means that employers are going to be tasked with having to determine which jobs to compare for purposes of complying with the law. The guidance expands on the comparable work definition by focusing on the substantially similar language of the statute. For positions to have substantially similar skill, effort, and responsibility does not mean that those factors must be identical, but rather the factors need only be significantly similar or have a great continuity. So let's talk a bit about one of the other really important things. The law in Massachusetts makes it clear that employees' salary histories are not a defense to liability. And indeed, Massachusetts was the first state to ban employers from asking job applicants about their salary history prior to making the job offer. Importantly, the law prohibits employers from seeking salary or wage history from a prospective employee on their own or through a recruiter or headhunter. Employers may still inquire about a prospective employee's requirements or expectations, but they cannot ask what they've been making either in their salary or their benefits. Now, while I talk about this as being true in Massachusetts, it is also a best practice in other parts of the country. Now, here's a tip. Employers, at a minimum, should review their job application forms and other similar documentation to eliminate any questions concerning the applicant's salary history. Employers should also train their human resources or hiring personnel, including recruiters and headhunters, so that they are aware of this new restriction and do not violate it during the interview process. Massachusetts also mandated that employers in the Commonwealth must perform equal pay audits. And we're going to talk later on in the program quite a bit about what an equal pay audit should look like. Another thing that Massachusetts requires is that if there is a disparity in pay between a man and a woman, you must raise the lower person's salary to the level of the higher paid employee and not the other way around. They also say that in Massachusetts, you can't prohibit employees from discussing their pay with their fellow coworkers. That would also, by the way, be a violation of the National Labor Relations Act, which provides for the right to concert. And here's another tip. So break out those writing sticks and get going. Employers should ensure that employee handbooks and other policies do not have language that either explicitly or implicitly prohibits employees from discussing their wages, benefits, or other compensation. Another tip, think about retaliation. And this is really important. If an employee comes to you and says, hey, I'm not being paid properly, or I felt the questions asked on an interview were inappropriate, and anything along those lines, be careful with retaliation. That R word is nasty and it'll get you every time. So please be careful of that. So what's the harm caused by an equal pay claim? Well, from the employer's perspective, let's talk about what equal pay looks like. It could be having to pay back wages, back benefits. It could be a double or even a triple damage, depending upon what state you're in. You could be looking at having to pay a lot of legal fees to your attorney. You may, if you're unsuccessful in defending the case, be paying legal fees to the attorney for the plaintiff. And employee engagement and morale will suffer if employees believe that there are some pay practice concerns. There's turnover. People leave. You've got that learning curve when a new person comes in. You have diminished talent because you're losing good people for the wrong reasons. From the employee's perspective, finances and the impact on the family can be devastating. So these are all good, valid reasons why it's important to get your pay practices right. Now, let's talk about contributing factors. And there are a number of different reasons why companies have pay problems. One of them is what we talked about before. I walk in an interview and I say, this is what I'm making. They either match it or they offer 5–10% more than whatever it is I'm earning. And a female comes in and if she's already earning only 81% of what I'm earning or more if she's a person of color, then they're going to keep paying her less, and they're going to be paying me, and that's something that's got to be corrected. Decentralized employment decisions. In some companies, you go to a manager or your boss and you say, I'd like a raise. And if you catch them in a good mood, you get one thing. If you catch them in a bad mood, you get another. And that's because there's a lack of structure. A poor structure is a big problem. Poor structure means that the people's compensation is across the board, and that could be a problem. There could be other issues with a lack of structure. For example, if I'm working for a manager and the manager and I get along well and we go out and we get a drink every week or, we get together socially and he likes me and gets me and all that, he might give me a 5% raise, but he might give a female only 2% or 3% or even less. And each year, the difference between what I'm making and what she's making continues to grow, even though she may very well be, and in the case of me, likely is a much better employee than I can ever be. So the lack of structure leads to these kinds of decisions being made. And one thing that's really important is if you do see a disparity in pay in a department, it's important to review what the thought process was for the manager that may have led to that disparity. Mergers and acquisitions. When you acquire another company, you can run into some big differences, and this could be a real problem. And I think it's something that it's important to consider that when you bring in another company and they've got their pay bands and you've got your pay bands and they're paying women or maybe people of color at a lower level than what you're paying, even though you just brought this company in or you just merged, you still are responsible for equal pay. And the cost to you is going to be the cost of raising those salaries. And if you do it promptly, you won't run into legal issues, but maybe it's something you might want to think about doing before you bring the company in. Then you get into periods of rapid growth or downsizing. And this is an area which is directly relevant because of what's going on with the coronavirus. And that impact of the virus will be real for companies. It will become increasingly difficult for companies to continue to employ an entire team at full salary. Difficult decisions are going to have to be made. Reducing compensation or benefits or reductions in force will likely result in pay bands going out of whack. It is critical that time is taken for employers to consider changes from the perspective of the attorneys chomping at the bit to second-guess your decisions. That's right. That famous law firm, Dewey, Cheatham, and Howe, will be looking for disparate impact on any protected group when it comes to layoffs or RIFs, reductions in force. They will also scrutinize the data to determine whether there is now an opening to argue for equal pay. So that's something that's really, really important for you to be thinking about. And then last but not least is there are times when bias plays a role in decisions regarding how much people are going to be making and maybe an unequal advancement. So I think it's really important that you consider bias and what steps you're going to take to ensure that is not a problem in your organization. So now it's time for the top 10 list. The first thing we're going to talk about is recruiters and managers. Recruiters and managers in Massachusetts should already have been trained that they cannot ask about salary and benefit history during the interview process, and certainly not until after an offer has been made. But I think it makes sense to take the time to train not just the recruiters or the people in the HR who do hiring, but managers from different departments who may sit on or even privately do an interview with somebody. So I think the first thing we do is we consider how well prepared we are with those managers and recruiters to make sure that they don't ask questions during the interview process that are illegal. And the second is look at your onboard processes. If you have a print application that you're handing to people when they come in the door for an interview, make sure it's not asking about current salary or benefits or whether you have benefits, what kind of benefits you have. And by the way, as an extra added benefit, pun intended, also check to see whether or not it asked for the year in which you had your college graduation or high school graduation. There are some forms, remarkably, still floating around that drive me bonkers that are asking people to indicate the name of their high school and the year they graduated. Well, that narrows down how old somebody is. That's an Age Discrimination in Employment Act violation. So take some time to look at the print application, but also your online portals. Are we asking for how much they're making, what the benefits are when they're going through that online process? Let's make sure we don't let that become a problem. Your recruiters, headhunters, if they are asking for salary and benefit history during the process, you may become liable by their errors because it might be almost like a joint employer kind of concern. So please be careful about that. And consider how raises are determined in the company. What steps are taken to ensure that we have an objective as opposed to a subjective process for deciding about raises. So for example, in some companies, the raise is determined based upon the performance evaluation. The performance evaluation is issued by the manager. Now, the manager may have a preference towards people who are similar to the manager, gender, race, age. A person who's not similar may be held to a different and more stringent status, and in that instance, the difference between a 5 and a 2 or a 3 may be the difference between the amount of raise that an employee is receiving, and that can create problems where we're out of whack. Same thing for promotions. We need to think carefully about how people get promoted in your company. Is it the decision that's being made by that manager on an island with all sorts of autonomy, or is it something that is more closely monitored, in the HR department? Is it centralized as opposed to decentralized? This is, again, an example where we can run into exposure in an equal opportunity kind of setting. Now, the next one, again, going back to the mergers and acquisitions, imagine ABB Corp, which has 500 employees, and it acquires a company called Columbus, which is a rather rinky-dink small company with only 15 employees. It is in the horseshoe business. Columbus is cheap and grossly underpays its employees, well below market value. So an employee at Columbus is making $50,000, and the comparable employee working for ABB is making $105,000. ABB's team consists in one particular department of all men, and the team that's brought in from Columbus in that department, they're all females. You guessed it, you have a pay equity problem, and steps will have to be taken to raise the salary of the women who had been working in the horseshoe business for Columbus to the comparable salary that the men for ABB were earning. Now, the pandemic is going to create equal pay and equal opportunity issues. So if you are struggling with that incredibly challenging, difficult issue, what am I going to do to trim my overhead so I can survive over the next 4 to 6 to 8 weeks? I think it's important that you look at it from the lens of those folks over at Dewey, Cheatham, and Howe, because if a person is let go, or their salary is reduced. And if it's not an across-the-board situation, many of these people are going to go to one of these attorneys. And this is what happens when they call Dewey Cheatham. The phone gets answered, Dewey Cheatham, and how may I help you? And then they're going to be looking at your data. They're going to be looking at the statistics provided by that individual. So the first thing you need to do is identify ways that you can trim your overhead. Then you want to take a look at the numbers to see whether there's a disparate impact on any protected group. The third thing you want to do is document why you are taking these steps. Documentation is something that is incredibly important so that if someone like me is going into court on your behalf, I've got the goods to explain why you're doing what you're doing. And documentation should be, to the extent possible, objective as opposed to subjective, so that people who review those documents say, I get it. I see why you did what you did, and it makes really good sense. So that's important. Now, I think that the last part of this is thinking about how you're going to communicate with your team as you're going through the process, and do your best to communicate in ways where you're not promising things you cannot deliver, but you're promising to do your best. And I think that's all really anybody can ask of you in that scenario. So let's talk about the audit. And I'm sure this is the last thing that you want to be thinking about right now while we are all scrambling. But when things do settle down, if you have not done an audit for gender, for race, national origin, and ethnicity regarding equal pay, I think that is something that you want to think about so you don't end up having to defend potential class litigation or systemic litigation claims in this area. So I think it's incredibly just important to think about it. When you do an audit, there are a couple of things that are good to do in the beginning. One is to define what you're looking to audit, define your approach, make it very clear that your terms are consistent. So if you've got more than one person, you're going to make sure that you are all using the same definitions. And what is the scope? Is it a gender-based audit? Is it going to be race and gender, a religion and gender? Is it going to be for disability purposes? Think about the scope. Think about the protocols. What information are you using? How far back are you going? Are you going to make sure that the job descriptions and what people are actually doing are the same? I did an audit late last year for a company that had employees in several states, and remarkably, I would say about a third of their employees were not actually doing the same thing that was listed in the job description. So it's very important to make sure you know what they actually are doing, not just what their title is. You may want to have an attorney involved in the process because communication with an attorney, depending upon where you are, likely falls under attorney-client privilege, and that could be incredibly attractive for companies. And the next thing I want to do is I want to get into the bona fide defenses that you have when you've got an equal pay audit or equal pay claim. And there are 6 defenses. And let's talk about the word bona fide. Bona fide is important because bona fide is good faith. It's, again, and I've said it several times, an objective assessment as opposed to a subjective assessment. And when you talk about bona fide seniority system, it is a system that recognizes and compensates employees based on length of service with the employer, excluding time spent on leave due to pregnancy-related conditions and protected parental, family, and medical leave. So in a seniority system, it's really nice to say when we're doing the audit, oh, well, he's been there longer. That's why he's making more than she's doing. But other things that someone might look at from the EEOC or a state division or an attorney or judge, well, this seniority system, is it mentioned anywhere in the employee manual? In your handbook? Is this something that you just thought of because it was a convenient defense? And that's where that whole bona fide thing comes in. A bona fide merit system is defined as a system that provides for variations in pay based upon employee performance as measured through legitimate job-related criteria, such as annual performance ratings that are akin to take into account in setting salaries for the following year. Now, again, merit becomes a problem. Think about merit in the following. You go to a restaurant for a steak dinner, and the steak is really good. The wine is good. The service is good. The atmosphere is very nice. The lighting is very nice. The amount that you pay is in keeping with what you expected. That's all very good, right? Well, not necessarily. What if you go in and you're looking for a flaw and the wait staff took too long to come over? They were hovering too long. You thought it was too loud. You thought it was too dark. You could look at it in a very negative way or a positive way. So merit systems are very difficult to measure, without having a good bona fide basis for it. And the same is true with productivity. A productivity system is defined as a system that measures earnings by quantity or quality of production, sales, revenue, in a uniform, reasonably objective fashion, piecemeal, commissions, things along those lines. So if you have a system of paying commissions to people based upon their productivity, that could become a very good way for you to measure productivity and use that as a basis for the bona fide defense. But here's where the problem comes in. How does the salesperson get the leads? Are they being given by the manager of the team? Is the manager giving the leads out in a way that's uniform, that's fair, that makes good sense? If the answer is yes, again, an objective review, then I think you're okay. Let's move to geographic location, and this is where we consider things like cost of living. If you're living in a rural farm area in the Midwest or perhaps in the South versus somebody who's living in San Francisco or New York City, or LA, that are much more expensive to live in, it's okay to pay different salaries based upon the geographic location. Education, training, or experience, if it's reasonably related to the job, this could become a factor for paying someone differently. However, if it's an issue of training, and this is training offered by the company, and it could be given any time of the day, but the manager decides to train at 7 a.m. during the week, knowing full well that 2 or 3 members of the team are moms who've got to get the kids off to school in the morning, and there's no way in the world they can take that training, and then all of a sudden they're making a lot less than the men, or perhaps women with no kids who can do a training anytime they want. So that's one concern. The second is if it's education or experience, it's got to be related to the job. So, for example, you've got a person who's got this big old fancy degree, from MIT in engineering or science, and they're working as an executive coach. Well, it's nice to have that degree, but it's never going to come into play in the coaching. there's a very different skill set and an equally important skill set that someone comes in who's coaching, but it's got nothing to do with the degree in engineering from MIT. No disrespect to anybody in the audience who went to MIT. And the last one is travel. Travel isn't the 35, 40-minute commute to work every day. Travel would be, for example, you've got to go out on business trips, and 2 out of every 4 weeks you're gone for at least 2 or 3 nights, and you're flying by plane somewhere to go on these trips. Then travel can become a factor. So when you review this information, another tip, please, please, please document. If I'm in court and I'm going to explain away why you thought it was okay to have people making different salaries because of one or more of these 6 factors, and you don't give me any documentation, and for those of you who may remember the honeymooners, you don't want me going in front of the judge when asked for the documentation saying, and I quote, hamina, judge, hamina. You want me actually to have the paperwork in front of me. Another tip, employers should begin analyzing their current compensation structures with a specific focus on how and why they calculate differences in pay for certain positions. Another tip, review the job descriptions and ask questions, kick the tires. Don't stop at the job description. Make sure you've got a clear understanding of exactly what these people are doing, and then you're going to be in good shape. So, again, document. I can't stress that enough. And as a reminder, if you've got to correct a disparity in pay, do so by raising the salary of the lower paid person to the salary and benefits of the higher paid person. Number 9, retaliation, that R word. Make sure if anybody does make a complaint about equal pay or equal opportunity, HR knows about it, and that no adverse employment action is taken against that person without a very careful review by HR and by legal. Now, if you do find that you've got some serious problems where you've got a lot of people who are paid less than they should be making, or if people are not advancing as much as they should, based upon gender or possibly race, you've got to do an outreach and figure out why this is. You may want to consider a diversity and inclusion program, which would be a really good thing to do once things get back to a new normal, around us because of this virus. One of my clients did something years ago, which was an ex-corp university, and this was a way to give the training and experience people needed to be able to advance and thrive in their careers, and at the same time also make for a more diverse senior level in the company. And because of the success that one client had, I've recommended that to several other clients, and they've done it, and they've been very, very happy with that kind of a program. And if you do any kind of training, consider perception. Perception is such an important thing in the company. We want this to be a great place to work. Just keep pushing that as much as you possibly can. And I think I'm out of time. So thank you all for attending the program today. Please feel free to reach out to me if you've got questions regarding what we talked about in this program, or if you've got any questions regarding how your company is going to make it in these really unsettling and scary times. My direct dial will go to my cell phone, and I'm happy to talk to you anytime. It's 617-532-8035. Thank you all, and good luck to everybody. Bye now.